Crimes Amendment Bill number 2 interrupted debate on first reading.
When the debate was interrupted on the first reading, Lynn Pillay was speaking. She has 3 minutes and 30 seconds remaining to speak should she choose to have that time. Otherwise, Keith Locke.
Thank you. This bill, the Crimes Amendment Bill number 2, has a number of different elements to it, and there are some parts of this bill that the Green Party supports and some parts that we're particularly worried about. On balance, we've decided to oppose this bill at the first reading, although we're hopeful that when it goes to Select Committee, a number of changes will be made and we'll be able to support it at subsequent stages. One of the pieces of the bill that's not at the top of the bill and that might have got lost a bit in the commentary, but we think it's very important, is the section which gravely limits the traditional, what's called the claim of right, sometimes called the colour of right. And we are worried that there's been somewhat of a knee-jerk reaction to the decision in a case often known as the Waihopai 3 case, where 3 men charged with criminal damage at the Waihopai spy station were found not guilty, and they used as a key part of their defence the claim of right. And it is unfortunate when changes in law are made mainly in response to the result of one court case, particularly when we're looking here at a common law provision that has existed in many countries, still exists in many countries, and has a very important tradition in common law. Now, just to go back to the original text of the claim of right in the Crimes Act before this amending bill, claim of right in relation to any act means a belief that the act is lawful, although that belief may be based on ignorance or mistake of fact or of any matter of law other than the enactment against which the offence is alleged to have been committed. That is, it's a fairly broad concept that even though you can't misinterpret the actual offence for which you're charged, it means if you put it in a broader context or make some mistake in relation to that broader context or some other factor comes in, then perhaps you can be found to be not guilty. Now, the change suggested in this bill is to restrict the use of the claim of right to cases where the person charged has some proprietary or possessory right in property. That is, that the amendment takes out the bit that a belief that the act is lawful and substitutes at the time of the act that there's a belief at the time of the act of a proprietary or possessory right in property being property in relation to which the offence is alleged to have been committed. So, just to put it in its simplest terms, this could apply, and correctly apply, to a case where somebody picks up a bag, as some of us have done at times, runs off with a bag thinking it is our bag, and then later on you realise it was someone else's bag, but it looked identical to the bag picked up. And in that case, technically you're guilty of theft because you've run away with somebody else's bag, but in fact in a court setting they say no, you had an honest belief that it was your bag. So that restricting the clause in this way, the claim of right in this way, does have some application, but a very limited application, and it wouldn't apply even to something which is fairly similar in a proprietal sense or property sense, where, for example, you hear a scream, you think it's someone in distress, you're sitting in your own home, you hear a scream, you think it's coming from next door, someone's being attacked, you go next door and bash down the door because you think it's rather urgent, and then you realise really the scream came from the next door over, and even that may be something else, maybe someone screaming at the All Blacks on television or something. But you had a genuine belief that you were trying to help someone in distress, yet your next door neighbour, whose door you've just bashed down, says, well, hold on, I'm going to take you to court because this was willful damage, etc. And you might try to use the claim of right, which you traditionally would use, but in this case, because you had no proprietary relationship to the property next door, you couldn't claim the claim of right. Now, in the Waihopai case, it was broader than that, as it has been in many other cases. That is, the three people who were charged with criminal damage said, yes, we did conduct an action which caused some damage to the dome surrounding the dish at Waihopai, and they didn't deny that, but they said that they were actually, the context or the claim of right took into account a broader law, international laws against committing murder in wars, conducting an illegal war in the case of Iraq, which is what they referred to a lot in the court case, and the rights that New Zealand criminal court, etc., etc. They had a lot of international law that they said that they were obeying, and which sort of outweighed or provided a context for them committing criminal damage at Waihopai in terms of an effect on that dome. And when claim of right is being discussed in legal circles, it's not just an honest belief, and it's not just a moral entitlement. There has to also be a legal entitlement, which is why they had to provide evidence of these other laws in their court case, and why they had to present evidence that Waihopai had, the spy station there, had some relationship to the breaking of those laws. And they particularly, if you read the court transcript, refer to the evidence of a government communications security headquarters whistleblower in Britain who came out with a memo from a chap called Frank Kozer of the National Security Agency, of which Waihopai is linked up to and does its spying for, who said just prior to the invasion of Iraq that the National Security Agency and its offshoots would conduct a whole set of interceptions, and he specified it, of dissident members of the UN Security Council to try and get a majority for the American invasion of Iraq. They failed to get that majority, but in the process spied illegally on United Nations delegations in their communications back to their homes. So there was a whole lot of things there proving, and one of the problems with this is that in this particular case, they were challenging government policies, and governments, of course, can react by saying, well, we don't want our government policies being attacked, so we will change the law. And that's what's happening in this case. Rather than the government admitting, well, perhaps the court, perhaps the jury, perhaps the judge got it right in the Waihopai case, let's just throw out the colour bright, even though it has this long tradition. And I think that's a very unfortunate thing. Now, with the other part of the Crimes Amendment Bill number 2, we do support the intention of the bill to make it more difficult, to put more moral sanction on assaults on children. That is very good. But as we've said in the past, and our co-leader Materia Ture has said, we are concerned that in lengthening the sentences that apply, particularly to family members in a place where the children might be abused, it might actually provide a certain disincentive from reporting crimes, because family members won't want to get the other family member into trouble. Now they'll be getting a 10-year sentence. It's a question. Some of the people in that household might be abused and very scared of coming forward to the police. There's all of those problems, and it's much better to somehow bring in techniques and support for families and extended families to bring them on side so that they can constrain and prevent the violence in the home. So the Green Party is a bit critical of some of those provisions, and our criticisms parallel those of the New Zealand Nurses Organisation, the National...
I'm sorry to interrupt the honourable member. His time has expired. I call Todd McClay.
Mr Speaker, thank you. It's a privilege to rise